I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what the day is, but it's exactly what you make it. So please don't go wasting, and I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. Of what a good day is. What a good day is. And that's exactly what the day.
All right, y'all, we finally made it. Oh my gosh. Good morning to everybody who's in the building. Appreciate y'all being here. We are back at it almost afternoon, I feel like. Good Lord. You know, sometimes things just be out here, you know, life be life. Shout out to everybody who's in the building. Y'all know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. You should be able to see me here shortly. Let me see. Let's see how we looking up in here. First of all, oh wee, there we go. Looking all crispy and clean on the screen. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, Classy Beats of ClassyBeats.com. Tonight we've got, we're gonna get into it today. I say tonight. See, I don't know what's going on today, but we're gonna get it right. Let me stop talking and say what's up to the people, man. Shout out to everybody who's in here. Of course, my awesome, amazing Amy is in the building, showing love. Thank you, Amy, for everything. I love you. I appreciate you. Thank you for all that you do. Oh, man. Les Cleaver is in the building. Perfect Pieces up in here. A-Fits, Alabama, Gigi. Michi is up in here. Rice Street in the building. What's up, my dog? Taco Tuesday is up in here. Good to see you, Taco Tuesday. We've got Alejandra. We have Carla, Shay, Valencia, Susan, Kara's up in here. Cameron is in the building. Tracy is in here snitching me. Said I was stalking Cat. Not what? Stop snitching, Tracy. I was definitely stalking Cat. Thank you, and big shout out to Cat Not Williams for some of the documents we're going to be covering today. She is always on it. Y'all make sure you go over there and support Cat. We've got Beverly in the building. Jay Buckmaster's up in here. Rona, good to see you. Wanda, Cynthia, Letitia. Linfinity is back at it. Cynthia, the real Magnolia. The real Magnolia. Okay, good to see you in here, the real Magnolia. We are going to get into it. So if y'all could do me a favor, I know y'all are going to have a good time, so you might as well go ahead and like the video on your way in. Not only is it free, not only does it help the channel continue to grow, but it does let the YouTube algorithm know that you're enjoying the show, and it shares the video with more people. So if you could take 2 seconds and like the video, and we're going to go ahead and get right into it, because we've got some, well, not really breaking news at this point. We're going to get into the breaking news in a second, but this news that we're going to cover first, and shout out and good morning to the Honorable Attorney Kel Bell in the building. Can y'all give it up to our amazing attorneys on the channel? Shout out to the Honorable Kel Bell. Always appreciate you being here and showing love. And shout out to Lady Rockstar over on X. Thank y'all to those of you who are watching on X too. All right. This one is tough for me. And it's really frustrating. I can't imagine how frustrating it is for Yak Gotti, his mother, his family, Doug Weinstein, after all the work he put in going 1-0 in criminal cases. Kayla Bumpus. I mean, everybody involved in this has to be so frustrated because it is official that Yak Gotti's bond has been denied. Now we're going to get a little bit into the why, what happened, why they're saying this is necessary. A lot of you may have seen the video that we posted yesterday, and we got to hear Judge McBurney being somewhat in shock, along with Kayla in the courtroom, along with Max Sharp, who was there just hanging out. And Judge McBurney said, well, it looks like, according to the probation officer, that there is a pending warrant for Yak Gotti's arrest. What? Now, no one found out about it until the day of his hearing, until the moment he was in his hearing. There's a lot of confusion in the courtroom. Kayla said, Judge, I don't understand what's going on here. I don't know why this is an issue now for something that happened in the past, but we're going to look into it and we're going to figure it out. As y'all know, Yak Gotti, he was unfortunately sent back to jail until this was figured out. And Judge McBurney said he was just going to put everything on hold. Well, as of yesterday, late yesterday afternoon, Judge McBurney did make an official decision. What does it say here? In the Superior Court of Fulton County, the state of Georgia, Diamante Kendrick versus the state of Georgia. This case came before the court for consideration of bond. Having considered the record and the relevant bond factors, the court now hereby orders that, of course, bond is denied for the following reasons. It's rough, man. Does the defendant possess a significant risk of fleeing the jurisdiction of the court or failing to appear in court when required? No, they don't have an issue with that. Here's what they do have an issue with. Defendant possesses a significant threat or danger to any persons, the community, or any property in the community. What? And again, Judge McBurney is going to base this off of the statement that came from the state where they're saying, hey, he had these things happen back in 2015. He's having these issues while he was in jail. He had a shank. Someone stole Yak Gotti's commissary. I'm not sure exactly what it was. He had some things stolen from him. And according to the state, they got him on camera saying, I got to do what I got to do to make sure that this doesn't continue to happen. So Yak Gotti, he went and attacked someone allegedly. And that was the reason that he's being charged with aggravated battery and aggravated assault. Also the riot in a penal institution, which we heard is really easy to get charged with. I mean, if you and another person get into an argument with somebody else, I mean, that could be considered a riot. So really some BS charges there. And that's the main reason that Judge McBurney is saying, oh, well, we can't give him the bond. And also, what else did they have on him? Defendant possesses a significant risk of committing a felony pending trial. Again, that's up to his discretion. I don't see where he's getting it from. And I don't think he necessarily ruled this because these things are true. I don't think Judge McBurney is saying he didn't have a choice because of this warrant that just appeared out of thin air. And we're going to get to the warrant here in a second. Also, shout out to Thugger Daily for all this information. You can go follow Thugger Daily on X and also have a link to Thugger Daily's X account in the description. It says the defendant has an active probation warrant in criminal action 15, and it has the number there, premised on the charges in this case. And then they have it attached. They have the warrant attached here. Until that probation warrant is resolved, bond is not appropriate in this matter, which it feels like he could have just put this statement in there and left out the other stuff. Because, I mean, come on. Yeah, guys, this stuff happened 10 years ago. And other than him defending himself in prison, what else is there to show that this is the case? So it's ordered on this day, the 18th of December, which was yesterday afternoon by Judge Robert McBurney. All right, let's look at this warrant and see what's going on here. State of Georgia versus Diamante Kendrick. Fulton County, original offenses, conspiracy, and then they have all these listed here, which I can't read because the font's too small, but y'all know the deal. To the sheriff of the above named county or other law enforcement officers of the state. Under authority of the Georgia Statewide Probation Act, you are hereby commanded to take the body of Diamante Kendrick. Ooh, why do they say it like that? Jeez. And safely keep him until he has returned to this court, there to answer to the charge in violation of the following conditions of probation, violation of a criminal law, which would be the fights he's gotten into in jail, unfortunately. Probationer is charged with violation of said conditions in willful disregard of a court order, specifically as follows. The defendant was arrested on March 17th, 2024 by Fulton County Sheriff's Office for 4 counts of unauthorized possession of a prohibited item by an inmate, cell phone. The defendant was arrested on June 20th, 2024 by Fulton County Sheriff's Office for aggravated assault, as we know, defending himself. Now, here comes the interesting part. The interesting part is the dates here. So this was sworn to and subscribed by community supervision officer, probation officer, who we got to hear from the other day, 12/18/2024. And then we have Judge Leftridge signing this yesterday as well. But then we don't have a date that it was issued. Why is this? And how could this be the case that we don't have a date that is issued on? I find this very strange, very peculiar. And we don't even know when on the 18th this came to be. It seems like what happened is this piece of paper, just like this, even without the judge's signature, because how could the judge give the signature if Judge McBurney was just finding out about it? And he just handed this to him and said, hey, Judge McBurney, this guy, he's got a warrant out. See, here's the warrant right here. We don't even know when this was issued. Are we supposed to assume that it was issued that same day, which would be even more corrupt and more insane, in my opinion? Obviously, we know Yak Gotti was found innocent on all charges. He was on the charge of RICO, and then he had a murder charge he was facing in the YSL trial. Both of those are gone. Now it seems like this is just some petty move to try and make him pay for being found not guilty, which is unfortunate. It's not surprising considering the DA that we're talking about here and this office and how they run things. The even more sad thing about this is what Kathy Russin said over from Law and Crime. We just found out this morning. She says Diamante Kendrick, aka Yak Gotti, is on the calendar for January 8th of 2025. Which means that he's going to be in jail for nearly another month. Let's see what today's date is, the 19th. So he's going to be in there 1 week, 2 weeks, about 3 weeks. He's got to be in jail. He's not going to be able to celebrate New Year's with his family, even though he just beat a murder charge and a RICO charge. He's not going to be there to celebrate New Year's. So another 3 weeks he has to sit in jail. Not only that, but for these charges, he could be facing up to 6 years in prison, which is insane. Beating all these charges just to be facing more charges. Not only that, but the charges that he's looking at facing, the only reason he's facing these charges is because he was in jail for a crime that he didn't commit. This is just so sad. Total BS. Y'all, please, please, please say a prayer for Yak Gotti, because he shouldn't have to deal with this, especially considering, I know jail politics don't count when it comes to the law, but he was there trying to defend himself, trying to survive in this jail that we know, according to the Department of Justice, is corrupt. And now he's having to deal with this. So he's going to have a plea and arraignment on the 8th. Of course, you know, we're going to be covering it here. I'm not sure who's going to be representing them on that. I just would assume that it's still going to be Caleb. So I know she'll be giving some updates on that too. And I'll keep you guys posted. Let me know what y'all think about this in the comments, in the chat. Very, 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 very sad. And y'all pray for Yak Gotti, man. Shout out to Michi in the building, dropping the 10 bomb. Can y'all imagine, man? Can you imagine beating a murder charge and then having to deal with this BS? What does Michi say? Michi says, I have to say this. I have to say, this is the most bogus shit I've ever heard. Fulton County has it out for this man. Mad he was found not guilty on all charges. Now pulling charges out of they. Yak needs to sue. I mean, what are you going to do? What are you going to do? You're put in this position. This is why, I mean, this system is so corrupt. Even outside of Fulton County. Think of just going into jail and trying to survive. If you defend yourself, if you stick up for yourself, I mean, you could possibly be facing more jail time just for being in there, even if you are innocent. I mean, Mr. Vegas said this can't be happening. It's happening, man. This is just a gross abuse of the law. And yes, he did these things while he was in prison. Fine. But I don't see how it counts or it applies in that way. It's sad, man. It's super, super sad. But thank you for the support, Michi. I appreciate it. I want to see what some of y'all are saying in here too. I'm lost because they're saying it's 2015, then mixing in other dates. Yeah, all of this is from a probation violation. And some of the things that he did while he was in jail. Allegedly had a cell phone, got into a fight, he had a shank. And if y'all want to, I can go back and let me find this here. I can find the video for you where the state actually speaks on what happened. And the reasons why they think he shouldn't get out. Let me see if I can find it here. I should have had this ready. But we've got, let me see. So there's that one. We got Kayla and Max. And they're trying, when you're hearing 2015, they're trying to use 2015 to say that because Yak Gotti was arrested for certain charges back in 2015, that he shouldn't be released because there's a risk. Here we go. I found it. Yeah, and they're saying Yak was the aggressor, exactly. Let me see if I can find it.
You know that. That's how it flows. And so if that warrant is out there, then we need to work through that. And setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted, or it's dismissed, or I don't know that judges tend to set bond on probation warrants. But if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him.
Discussing.
If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail I mean, he has
Might
not been
be.
charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone.
Well, Judge McBurney, it helps Fannie's ego. Let's be real. And Judge McBurney's basically saying what we've all been saying. It's like, why didn't this happen before yesterday? Why wait up until today? Judge McBurney's saying his hands are tied. He can't tell the DA, hey, you guys need to go ahead and either bring the indictment or the accusations or whatever you're going to do. Let's go ahead and get this out of the way. Mr. Kendrick has a right to say that, but he can't force the DA's hand, which is unfortunate. And these are the little games that they're playing. Judge McBurney sees it. He said they can do the cell phone here, and then they can do the assault here. And then 2 months later, they can do the other charges that happen. It's nasty
Well, this
work.
time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger
Please.
case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me?
So let me go back. That was Judge McBurney basically explaining, hey, we're going to try and get this figured out. I trust that the state will be able to get everything condensed into maybe 1 indictment. I don't trust that. Judge McBurney, but hey, you've been in here longer than me, so I'll take what you say. Let's go back and see what the state is trying to say, the reason that Yak shouldn't get bond.
Across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me.
I don't trust the state at all.
See, I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties. But could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. And I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation and then I'll get the warrant out to everyone.
And you see Kayla looking at Yak there. We talked about this ad nauseum, being like, huh? You know about a warrant? Nobody knew.
The defendant stands before you having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley.
Okay, so this happened in June, all right? So keeping the timeline.
Causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular.
And so what we have here is another "we believe" statement, right? We've seen this so much. We believe he's the main perpetrator, so we're going to keep him in jail for the next 3 weeks until we figure this out.
Case between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault.
This is probation.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. But they were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially saying, "What else am I going to do? It's about respect. Right, they're stealing my stuff. I got to do something." So I would disagree with the assertions that this is just a battery, and I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 1.
Yeah, and we don't need to go through all that again. I mean, it's just the state piling on saying, oh, well, because he did these things 10 years ago, it's possible that he might do something again. And even according to the state, from the body cam footage, he didn't say that he was going to attack somebody. He just said, I got to do something. That even there is not evidence showing that, Gotti was the one who did it. And all we have is body cam footage because we know the cameras in Rice Street, well, not Rice Street, but in Fulton County jail systems aren't working anyway. It's just a whole mess, man. Y'all pray for Gotti and anyone who's being held wrongfully in these prisons and just the conditions in general, because he shouldn't have to deal with this. He should be at home because he was already found not guilty. So let me know what y'all think. Thank you again to those of you who sent in super chats as well. Shout out to my guy Les Cleaver, says what goes around Fanny comes around. Your day is coming. We're going to get into that, actually. We've got some breaking news. This is going to be a good one. I know we had a segment that was a little bit sad just now, but this one's going to be a lot of fun. Y'all are going to enjoy this. So Fani Willis, oh my goodness, check this out. Fani Willis just got removed from the Trump case. She's taking a major L again. So this is very, very interesting. So Fani Willis taking a major L. Georgia Appeals Court disqualifies DA Fani Willis and her team from the Trump re-election or election interference case. Georgia court rules Fani Willis and her office have no authority to proceed. Hold this L, Fani. Let's see what Fox has to say about this.
Fulton County, Georgia. And here we go. A Georgia Court of Appeals has disqualified the Fulton County DA Fani Fulton County, Georgia. And here we go. A Georgia Court of Appeals has disqualified the Fulton County DA Fani Willis from that election interference case. It's coming down right now. The case
Take this L,
Trump and
Fani.
more than a dozen others already largely stalled, as you know. The new ruling means that it will be up to the prosecuting attorney's council in the state of Georgia to find another prosecutor to decide on the case.
Yes.
To take it over and make a decision as to whether or not they continue with a prosecution of the incoming president.
And former Deputy Assistant Attorney General John Yoo is here. John, does this mean that this is yet another one of the cases against Trump that could go away before he's president?
It's another example, Dana, of this lawfare campaign that was waged by Democrats, boomeranging back on them and falling all around their ears. Anyone who watched this trial, remember, this is the DA who claimed that the entire Trump reelection campaign was something like an organized crime racket that was intending to deprive everyone of our civil rights to vote. But remember, we saw the dramatic testimony over the summer of how DA Fani Willis had hired her boyfriend, essentially, to be the special counsel, overpaid him, and then had him investigate and bring charges against Donald Trump. It's a complete conflict of interest. And if you take a quick look at the Georgia Appeals Court decision here, that's what it says. There's such an appearance of impropriety, an appearance of a conflict of interest, that Fani Willis should not be the prosecutor. I think this spells yet another case that's going to have to either be suspended or more likely just ended and tossed out.
It's gone.
It's hard for me to see another Georgia district attorney wanting to take up this flawed case and try to prosecute Trump on these theories that his reelection campaign was some kind of criminal organized crime enterprise.
John.
And not to mention that we saw Ashley Merchant go out there and absolutely eviscerate Fani Willis on the stand. She was so defensive, saying, oh, well, I'm just trying to do my job. And you're actually the one that's the bad person in this. Shame, shame, shame.
Propriety, an appearance of a conflict of interest, that Fani Willis should not be the prosecutor. I think this spells yet another case that's going to have to either be suspended or more likely just ended and tossed out. It's hard for me to see another Georgia district attorney wanting to take up this flawed case and try to prosecute Trump on these theories that his reelection campaign was some kind of criminal organized crime enterprise.
Should be
John, a couple of things here. There are 14 others that face charges. I don't know what happens to them, but she can appeal to the state Supreme Court in Georgia. But given what the Supreme Court said in Washington about immunity, I mean, does the state Supreme Court even take her case in Georgia?
I doubt it.
It's a good question, Bill. I think what's going to happen here, along the lines of possible appeals and so on, is it looks likely, because of that presidential immunity decision by the Supreme Court, that any kind of state prosecution of President Trump would have to be at least suspended, if not dropped. You're seeing that going on, those arguments going on right now up in New York City with the case being heard by Judge Merchan. So even if they could get past immunity, they'd still have to suspend it while President Trump was in office. But furthermore, you'd have to go back and then scrub the whole indictment, scrub everything the grand jury did, and say you've got to eliminate anything that used official actions by President Trump, any evidence that came in from White House officials, from anything the president was doing in the Oval Office, they might actually fatally handicap this prosecution and require the whole thing to be dismissed.
It's interesting, too, because she had this novel way of trying to get at him through RICO. Was that a mistake as well? In addition to her personal behavior, obviously, is what they're saying here. But in a way, it was this like novel idea, like, how can I be the one to take Trump down? That's for, like, politically, she wanted that reputation.
Yep. We talked about
Dana,
this.
you and I remember we're Justice Department alums. Yeah, I remember you when you were there and I was there and we were, there after the days of 9/11. And you can use this kind of statute, RICO, to try to go after real organized crime, drug cartels, mafia organizations. DA Fani Willis introduced, I think, a really dangerous theory, was that we could use these powerful tools that are used for terrorists and drug cartels and apply them to political campaigns, and not just any political campaign, but the campaign by the leading opposition candidate at that time, Donald Trump, the head of one of the two major parties in the country. I think ultimately the whole thing would have been tossed out because it violated the free speech rights of Donald Trump, the free speech rights of the Republican Party, and actually a lot of Americans who supported him. So I think in the end, this whole thing was going to come crashing down around Fani Willis's and the Democratic Party's ears. Anyway.
Well, it seemed complicated from the beginning. There is that case here in New York that's still out there, the 34 counts. All
right, shout out to Fani Willis getting kicked up out of there. This is a great day. A great day. Another loss for Fani. Some of y'all were asking in the chat, how much time does she have left? Well, she's going to be in there for another 4 years. I did not vote for her to stay like the rest of Fulton County did, but kind of saw that one coming. And unfortunately, we still got some time with Fani Willis in office, but we'll see. Maybe some things can change. If she appeals this before the Georgia Supreme Court, I don't see this moving forward. I don't see them being like, yeah, Fani, you can go ahead. We've already seen what happened with a lot of the things that were going on during this YSL trial. Brian Steele had to go before the Supreme Court. Guys, can you intervene here? This whole trial is a mess. I've got Judge Glanville trying to lock me up just for not giving him the information he wanted. And now he's deciding he doesn't want to recuse himself on this case after he's clearly wrong, or at least give us an opportunity to look into it. And the Georgia Supreme Court said, yeah, Brian, you're right. We got to get this guy out of here. Just Glanville, you're gone. So in Fani Willis's case, I don't think they'll be so lenient either. Y'all have to let me know what you think in the comments and in the chat. This is absolutely crazy. I want to go back to and look at some of the things that happened while Ashley Merchant actually had Fani Willis on the stand. And y'all, if you haven't seen this, if you didn't get a chance to watch this, Ashley was cooking Fani Willis. So let's go back through that. I do want to read a little bit of this article, though, from the AJC. What did they say? Georgia Supreme Court of Appeals ruled on Thursday and today that Fulton County District Attorney Fani Willis and her office should be disqualified from the 2020 election interference case, a bombshell decision that upends the last remaining criminal case against incoming President Donald Trump. In a 2-1 opinion, a panel of judges, all GOP appointees, by the way, well, we know that had something to do with it, concluded that Fani Willis's one-time romantic relationship with former special prosecutor Nathan Wade constituted a conflict of interest that merited her dismissal from the case. How you can't deny her relationship with Nathan Wade. After carefully considering the trial court's finding in this order, we conclude that it is aired by failing to disqualify DA Fani Willis and her office. Judge Trenton Brown wrote for the majority. He was joined by Judge Todd Markle. A third judge, Benjamin Land, issued a strongly worded dissent. The appeals court's ruling overturns a March decision from the case trial judge Scott McAfee. The Fulton Superior Court judge ruled that while he didn't condone Willis's tremendous lapse in judgment, the defense failed to prove that DA had an actual conflict of interest, which is insane. He instead said that Willis could stay on the election case if Wade stepped aside, which the Marietta attorney did hours later. which is crazy. The decision is a massive blow to Willis. Yeah, is to Willis, one of the most recognizable prosecutors in the country, who carried a second term, or who cruised to a second term last month against a relatively inexperienced Republican opponent, Courtney Kramer, as we know. It also could be the death knell for the fourth and final case that resulted in criminal charges against Trump after he left office in January 2021. The decision is not the final word on the case, though. Willis is expected to appeal the ruling to the Supreme Court of Georgia. We all know she's not going to go down without a fight. The case could also be assigned to the prosecutor from another jurisdiction. No one's going to take this case, y'all. Not while the president's. He's about to go into office officially in about a month. So come on. In the majority ruling, the judges declined a separate request to dismiss the indictment entirely. A spokesperson from the DA did not immediately respond to the request for comment. In his dissent, Land said he was troubled that the two judges' majority had not deferred to McAfee's discretion and decision-making after assessing the credibility of witnesses and weighing all evidence. We should not lightly interfere with their work or weaken their discretion by imposing our will because we don't like the result. That's literally your job, being in the appeals. What are you talking about, Judge Land? That's the whole point of this process. Is did they get it right or did they get it wrong? And two judges said he got it wrong. So you're saying we're a good old boys club and hey, we had to stick together and whatever one judge says, we got to stand by it. Man, get out of here. Land wrote, referring generally to trial judges, because I am convinced that is what the majority has done in this case. I respectfully dissent. What happens next? Trump's reelection has spelled the end of the two pending federal criminal cases against him involving classified documents and his efforts to cling to power after the 2020 election. It is longstanding policy of the U.S. Department of Justice that sitting presidents cannot face federal prosecution. Additionally, Trump has indicated he would name an attorney general who would bring an end to the cases. Since the Fulton case is state and not federal, Trump could not shutter the prosecution like he could with the Justice Department probes, though constitutional law experts are doubtful that state DAs could prosecute Trump after his inauguration. Trump was also convicted earlier this year of 34 felonies related to hush money payments he made to a adult film star in advance of the 2016 election. A judge in Manhattan pressed pause on sentencing Trump after the outcome of the election became clear. Should Willis's disqualification stand, jurisdiction over the Trump case will shift to a nonpartisan state agency, the Prosecuting Attorneys Council of Georgia, which must decide whom to assign it to next. No one's going to want to try this. This is going to be a mess. P.S. The executive director of the Prosecuting Attorney Council of Georgia said he was still reviewing Thursday's option, but that it could be a while before his organization touches the case, if at all. It could take weeks or months for expected appeals to play out. So now let's go into Fani Willis up here. Look at this. Oh man, if y'all missed out on this, you missed out for real. I remember the lead attorney was covering this while it was all going on, and he was cooking Fani Willis as well, talking about she had her dress on backwards and all that. This was rough. Anyway, masterful work here by Ashley Merchant. The fact that Judge McAfee, after hearing all the evidence that came forward and seeing Fani Willis's behavior on the stand, I don't know how he could say she could proceed on this case, but we're going to get into it here in a second. We're going to watch a little bit of this. If y'all haven't checked it out, maybe one time we'll review the whole thing again because it was crazy. Here we go. Let me know if the sound is good too.
All right, we are back on the record. Deputy Scott, if you could swear in our next witness.
I would, and I do apologize. Anna, do me a favor. Put them on my knees on reading glasses. After you swear, don't put them on my knees. You can swear, you can go ahead and swear, so I don't hold it before.
swear on finding the testimony?
Yes, Chelsea. District Attorney Fani, F-A-N-I. Last name is Willis.
Oh, it's Fani. We've been saying it wrong this whole time.
There were people I was pacing in my office. Okay. And I heard someone yell, "His testimony is done." It only made sense to me that I would be your next witness. And I've been very anxious to have this conversation with you today. So I ran to the courtroom.
So as soon as you heard that Mr. Wade was done testifying, that's when you just assumed you would be the next witness?
It only makes sense.
Did you listen to any of the testimony?
I've been in my office pacing, ma'am.
Did you listen to any of the arguments?
I did hear the arguments this morning. It's ridiculous to me that you lied on Monday, and yet here we still are. And I did listen to that argument.
All right, so that was it, just the argument, no testimony.
Right, I listened to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday. And I'm actually surprised that the hearing continued, but since it did, here I am.
Great. So let's
shout out to Adam
talk
Abadi.
about, first, let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade and talk to him about the motion that I filed to disqualify you?
On this first January motion?
Yes.
I don't know if you could say talked about. I probably had some choice words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman. Me, not so much.
Okay, but my question was, did you have a conversation with him?
I didn't have a substantive conversation.
You did not?
I read this motion, skimmed it more so, and I've probably said some choice things to him about some of the lies that were told.
Okay.
Y'all see where Ms. Love gets it from, right? Good gosh, man. Y'all want to have dinner with Fanny? Let me know in the chat. Jesus, man.
Put it in the media because, we used to be in a day and time where you had 60 Minutes and people did stories and they verified information, and you had this great reporting. But it seems today that a lawyer writes a lie and then it's printed for all of the world to see.
Well, I just want to make sure that you answer the question I asked, though. So my question was...
I'm going to object. It's been asked and answered.
Overruled, Mr. Abadi.
It is not asked and answered.
I told you what happened. I read the motion. I am sure I told him what my opinion of it is.
Okay.
And past that, we had no substantive conversation.
You did not? Okay.
Is there something you didn't understand?
No, I just wanted to make sure that you did not have a meeting with him in the conference room to discuss the motion.
Next question,
No.
Ms. Merchant.
So in the conference room of my office, within this week, you produced some financial document. That financial document was given to me, something, and I'm not even sure it was given it to him by me or Mr. Abadi gave it to me. And I think he showed me a document in our conference room. But as far as a substantive conversation, I don't believe I've had any conversation with him that is substantive related to this.
Okay.
I have had conversations with him since you filed the motion, but they wouldn't be substantive to this. He sent me very nice sermons that have been done. And so we've had conversations about, did you listen to that sermon? Things of that nature. And I would say they were in relationship to this because I think he did it to be kind.
Oh my God.
Let's start back in 2019.
Yep.
So you and Mr. Wade met in October 2019 at a conference?
That is correct. And I think in one of your motions you tried to implicate I slept with him at that conference, which I find to be extremely offensive. I stayed at that
It's probably
conference.
true.
Mr. Wade was my teacher. I did not meet him when he taught the class. I was standing outside talking to Lisa Reeves, who is a judge. Me and her were just having a conversation. Mr. Wade walks up. I think they hug each other. They have some brief conversation. She introduces us.
Your Honor, I'm going to object. We kind of thought that when you asked the question, you didn't answer the question, not a speech, so I object to the speech.
I believe I'm able to explain my answers.
I believe she's able to explain her answers.
And that's
Ms. Merchant, that's okay. I can handle it. Ms. Willis, I'll ask you to listen to the answer, or excuse me, the question. and keep the answers confined to the question as best you can. I think you'll have more than enough ample opportunity.
It's crazy.
On when the state.
Well, it's highly offensive when someone lies on you, and it's highly offensive when they try
Look
to.
at her arguing with the judge, man. Oh, you know what happened? Miss Love was watching this and she got all hyped up. She said, yeah, watch me get Glanville. I'm going to have this whole courtroom under control. And she had him. And then you know who came in there next
These niggas lacking.
and set him straight. Shout out to Judge Whitaker.
Implicate that you slept with somebody the first day you met with them, and I take exception to it.
All right. Well, Ms. Wills, she'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
Thank you, Judge. So again, my
Look at
question
this
was,
lady.
you all met at
I
that conference,
can't.
though, right?
We did. The meeting, he, as I stated, he taught the class. I did not actually meet him when he taught the class. I walked out of the class, and I'm not sure if it was that exact class or we had went to lunch, but we were standing in the vestibule, like outside of the class. Me and Judge Reeves were having a conversation. She had worked at a law firm I worked at back in 1996.
We're getting way far. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that
She's
conference.
explaining how she met Mr. Wade, which was exactly the question asked by Ms. Merchant. These answers are more than appropriate.
No,
Ms.
they're
Merchant,
not.
if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade October 2019 at the judges conference?
We haven't gotten to the point where Ms. Willis should be treated hostile in this situation.
I think we
I
have.
very much want to be here, so I'm not a hostile witness. I very much want to be
Not
here.
so much that you're hostile, Ms. Willis, it'd be an adverse witness.
not
Your
hostile?
interests are opposed, Ms. Merchant's.
Thank you. Merchant's interests are contrary to democracy, Your Honor, not to mine.
Jeez.
Just ask that we
Keep things moving, Ms. Merchant.
He's just, Judge McAfee, what are you doing? I know that's your boss, but dang. Y'all see this? And after all of this, we're only 6 minutes into this. And there's a part 2. That's 2 hours long. Even after all this, Judge McAfee said, yeah, sure, you can handle this case. What? Good God.
Next question.
This is rough.
Okay, so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain my answers. When I met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And he walked to the parking lot.
So after that, you started dating shortly thereafter, correct?
That's a lie. That's one of your lies.
Okay. Do you know Robin Yurdy?
I know her as Robin Bryant. I knew her. So Robin did not go to my college. She went to the college of, I went to Howard University. She went to Morgan State. I met her through some people I knew. In college, we hung out a bit. Not much because she was in Baltimore and I was in Washington, D.C. But we hung out a bit. After college, I lost contact with her. I probably didn't see Robin again until maybe 7 or 8 years ago, a chance meeting here in Atlanta. But we did not have a consistent relationship from when I left college and came to Emory Law School here in Atlanta. But 8 to 10 years ago, just by happenstance, I ran into her.
So
she was in Atlanta.
You have been friends with Robin
Tone change, she's
for
lying.
30-something years.
Did you hear my answer, Matt?
Yes, and I'm asking if you've been friends with her for 30-something years.
I've known her for 30-something years. We certainly hung out and partied together in college. She was from the D.C. area. She would come home, we'd party together. Wasn't close, but she was certainly in the girlfriends that party together. And then, like I said, I ran into her about 10 years ago in Atlanta, Georgia. So we didn't talk throughout that time period. I didn't see her. I didn't even know where she was. When I ran into her, I was surprised she was in Atlanta. And so, yes, I have known her probably since 1990, 1991, but we have not maintained a consistent relationship that whole time.
For the last 10 years, or 5, whatever you'd like to classify it as, have you been friends with her?
I have not spoken to Robin in over a year. I certainly do not consider her a friend now. I think that she, you know, there's a saying, no good deed goes unpunished, and I think that she betrayed our friendship.
So let's narrow it down, the timeline now. So my questions are going to be from the time period of 2019 until she no longer was employed for you, the last time you all talked. So
This is
all
your
of my
district
next
attorney.
questions are
Our
just
district
focused on that
attorney.
time frame, okay?
Yes, ma'am.
Up until she left your office.
Yes, ma'am.
During 2019, you all were friends, correct?
Yes, we knew each other in 2019.
During 2020, you all were friends, correct?
We were friends during that time period.
During 2021, you all were friends, correct?
Yes.
Okay. And such good friends that when you needed a place to stay, you asked her if you could take over her lease.
That's a lie.
You did
That's
not move into her apartment?
I
or her
did, but
condo?
that's not the way you characterize it. Is wrong.
I asked if you could take over her lease.
I did
Answer the
not
question.
ask if I could take over her lease.
Did you move into her apartment?
I moved into her condo in April of 21. The circumstances around that were that Robin met her husband. They wanted to move into another and separate place. She wanted to get rid of her condo. My father was living with me at the house. Because of this case and because of my stance on gangs, my life was being threatened regularly. My father urged me to leave our home. At the same time, as luck would have it, Robin wanted to give up her lease because she wanted to move in with this new man she met, who eventually became her husband. And so, as life circumstances worked, my dad was begging me to leave the house. He was afraid for me, afraid for his grandchildren. She wanted someone to take over her lease so that she didn't, have to pay a fee or get abandoned. And so, I don't remember when, but probably March or April of 21, I moved in and take over her lease.
And did you pay her or did you pay the leasing agent?
No, I don't even know who the leasing agent was. I paid her.
You paid her. Did you pay her cash or did you use a card?
There were some times that I would give her cash, but mostly I paid her via Cash App. That would be the most convenient thing. So I would not only give her her rent, but then like when the utilities would come in, whatever the utility was, she might be like, I need $70, I need $100, whatever it was. And we never had a problem with money. Whatever she told me it was, I never asked to see a bill. I never questioned her. I just gave it to her.
What?
She was just making it rain over there on her friend. All right, so let's get into figuring out what happened and why it happened. So this is the actual document. And again, shout out to Kat Not Williams for getting this over to me. Appreciate you, Kat. Y'all make sure you go show Kat some love. This is the decision by the Court of Appeals of Georgia. Lord have mercy. I can't take too much of Fani Willis up in here. Oh, man. There's so much I want to say, but we'll go ahead and get into it. All right, check this out. Here we go. Second Division, Brown, Markle, and Watkins, JJ. Yep, the December 19th, which is today, 2024, in the Court of Appeals of Georgia. Here we go. Michael Roman, David Schaefer, Robert Chenley, Mark Meadows, Donald Trump, Kathleen Latham, Rudolph Giuliani, Jeffrey Clark, and Harrison Ford, collectively the Harrison Floyd, excuse me. Collectively, the appellants were charged in a 97-page indictment with RICO violations and other crimes in connection with the alleged conspiracy to unlawfully change the outcome of the 2020 presidential election. Pursuant to a granted oh my goodness, I can't do that one. Interlocutory. Oh my gosh, what? Application. The appellate's appeal from the trial court's order denying their motions to dismiss the indictment and granting in part their motions to disqualify the Atlanta Judicial Circuit District Attorney Fani Willis, who's going to be mentioned here moving forward as DA Willis, and her office collectively. The appellants assert numerous grounds to reverse the trial court's order, including the trial court imposed an improper remedy after concluding that DA Willis's prosecution is encumbered by a significant appearance of impropriety, not grounded on mere status alone, but instead resulting from specific conduct impacting more than a mere nebulous public interest because it concerns a public prosecutor. In response, the state asked this court to affirm the trial court's order in its totality, including the imposition of an alternative remedy requiring that either DA Willis, along with the whole of her office, step aside and refer the case to the prosecuting attorney's counsel for reassignment, or Special Assistant District Attorney Nathan Wade, or SADA Wade, as he's going to be referred to, withdraw from the case. Importantly, the state has not filed a cross appeal asserting that the trial court's finding of this appearance of impropriety should be reversed. Accordingly, whether the evidence presented to the trial court adequately supported under the appropriate standard of review on appeal, its finding of the existence of an appearance of impropriety is not before this court. Instead, we must determine whether the remedy fashioned by the trial court for this undisputed finding of significant appearance of impropriety was improper as contended by the appellates. For the reasons explained below, we conclude that it was, and therefore reverse the trial court's denial of the appellate's motion to disqualify. We affirm, however, the denial of appellate's motion to dismiss the indictment. All right, so there it is. Let's move forward because we know a lot of the background that happened, and they're going to go on through 30 plus pages explaining why all this happened, what happened. Fannie had a relationship with Nathan Wade, why they think that it was inappropriate, and moving on, so on and so forth. So I'm going to have a link to this document in the description for y'all as well. Shout out to Cat Not Williams for turning this over. But it'll be interesting to see what happens to this, especially when it comes to Fannie's career moving forward, because this RICO case, she got a few RICO charges under her belt, but it's pretty much falling apart. Let's be real. And she's scraping and scrambling as much as she can to try and get guilty pleas out of these guys. We're going to talk a little bit about Christian Eppinger coming up here shortly and what happened there. And it's going to be tough. It's going to be tough to see how the remaining of these defendants go throughout the trial, especially with Christian Eppinger specifically. It's going to be a tough case to beat because he's looking at a lot of time in prison. So how do y'all think this is going to affect Fannie, if at all? Do you think she's going to be fine with her secured 4 more years in office? Oh, let me know. This is tough. I did my part, though. I tried to get her up out of there. Nobody helped me, though. Shout out to Stephen G in here with the super chat. He dropped the 3 bomb and says, Rice Street, you've got room. Yeah, go ahead and make some space for Fannie. Oh, man. Tracy Fagan says, wow, sounds like Rico to me. With the 2 bomb. Thank you for the super chat. And I wonder if there's going to be charges brought against the DA's office here. That would be very interesting. I don't even know. I wonder if Kel Bell is still in here. I think I saw Kel Bell in here a minute ago. How would that even work if someone wanted to bring a lawsuit? Well, I know they could bring a lawsuit against the DA's office, but what could they possibly charge the DA's office with? And how would that even go down? That's interesting. Very interesting. Let me see. We've got a couple other things I wanted to get into for y'all. I know I mentioned Christian Eppinger. I think we should go ahead and get to him. And then I've got an update for y'all on Jay-Z as well. So we'll get into that here in a second. Let's go ahead and give you guys a little bit of background. Let me see if this is
new developments today.
Hold on a second. Boom, we got it. So let me give y'all an update on this, and then we'll get it to it. And again, thank y'all so much for these super chats. I will be reading those throughout the show as well. We got that one, and boom. All right, here we go. So as a lot of you know, recently Judge Whitaker, she had a plea hearing for the final plea hearing for the remaining defendants in the YSL trial. One of those defendants is Christian Eppinger. He is accused of shooting a police officer, shooting at another police officer. And of course, all of that was somehow lumped into the YSL trial. Now, as the trial went on, Christian Eppinger actually got severed from the YSL indictment. So he's still facing these charges, but they're not technically a part of this, the YSL trial. So we're going to be moving forward going into the second week in January, where we're going to see Judge Whitaker come back in and he's going to be on trial. But I wanted to give you guys a little bit more of a background into what actually happened in case you didn't know, and some of the things he's going through now when it comes to immunity he's trying to get for the things that he did leading up to this trial. Check this out.
Some new developments tonight in the YSL RICO trial. One of the defendants who's been in hot water has now been severed from the case, meaning he will now face a separate trial. We first told you last week a Fulton County deputy was arrested for trying to smuggle contraband to Christian Eppinger. Now today, a judge severed him from the case after the state accused his attorney of allowing him to use a laptop to communicate with that deputy on Instagram. Officials seized that laptop last week. Eppinger's attorney, Eric Johnson, has denied these claims. Still, the judge said the accusations presented a conflict of interest and cited safety as the reason for the severance.
All right, and then here's actually what happened. And of course, we got Fannie Willis back in here. Oh my gosh. We're going to look at the video from when everything went down with Christian. And then we actually are going to fast forward from this point to when the video was played in the courtroom. And we're going to bring back our guy, Keith Adams, here in a second. It's wild.
We're going to have the police department would like you to see the video of when this officer was shot, and then we will continue with questions, sir.
Chief Hampton will walk us through.
So again, what you'll see is, the subject being followed by Officer Rogers. Again, as Madam DA indicated, that he was, he was wanted. Officers were all hot on his trail. And again, we just want to show the level of violence and the total disregard of life that this individual had on Officer Rogers, as well as investigator Will Johnson. What you will see is Officer Rogers.
Let me rewind it a little bit for y'all so I can point him out. So this is Christian walking down the street here.
Indicated that he was, he was wanted. Officers were all hot on his trail.
And this is a police officer, jumps out of the car, goes towards Christian.
And again, we just want to show the level of violence and the total disregard of life that this individual had on Officer Rogers, as well as investigator Will Johnson.
Takes a gun, shoots at this police officer, and gets up out of there.
What you will see is Officer Rogers will get out of a marked patrol car. Right there, trying to take him into custody. There was a struggle, and it was at this time, with total disregard of 6 shots fired into Officer Rogers.
Did he just John Wick that thing? It looks like he holds. Is he holding 2 guns out at the same time? Christian, what are you doing, man? I'm not gonna lie, this one's gonna be tough, y'all.
And it was at this time, with total disregard of 6 shots fired into Officer Rogers. And so again, this is why we are displeased with this decision.
This video will be posted on the AP.
All right, so we're gonna get into the next next one. This is actually the first time they played the body cam footage in the YSL trial. And we're gonna bring back Keith Adams.
He's on the way. $61.70, $61.60. You up on SOS? On the ground, boy. On the ground. On the ground. On the ground. Get on the ground. Get on the ground, bro. Get on the ground. You got paper. Get on the ground. I ain't did nothing.
Dang. Yes, the car was marked. The first car was marked. The second one wasn't. And this is the officer that got shot. Yikes.
Thank you. Is it Sergeant?
Yes, it is.
Davis, true?
Correct.
Good afternoon, sir. My name is Keith Adams, and I represent Jeffrey Williams, gentleman sitting right there in the black.
Sure.
I want to ask you a couple questions about what we just saw, what we just saw on the screen.
The other police officer
These two
was,
videos.
yes.
One was a dash cam, one was a body cam, true?
That's correct.
Okay. Now, is it fair to say that you weren't involved in the case, but your role as manager of the dash cam department, body camera department, is what brings you in here?
Correct.
Okay. But you did have an opportunity to look at these videos and observe them, true?
I did.
And so you're able to testify that they are what they purport to be. They show images that are accurate, as best you can tell.
Correct.
Okay. And so what we're seeing is actually what happened out there that day.
Yes.
And what we're hearing is what happened and what was said and all the sounds and everything that happened at that time, true?
That's correct.
All right. Now, on the first one that we saw, which was, I believe, the body camera.
Correct.
That is, it starts with us, we see from inside of the vehicle. Is that right?
Correct.
Is it clear to you from looking at that, from the handcuffs that are hanging from in the front, that this is a police car that this gentleman is in, the officer? So it is a marked police car, and am I correct that we see it pull up and then come to a stop?
Yes.
And you saw in the video, did you not, and heard when the officer gets out of the car, right? You saw that?
Yes, I saw
right.
that.
You'd agree with me that he encounters this one person, the person who we come to know as Mr. Eppinger, right?
Yes.
All right. And Mr. Eppinger, this guy's by himself.
Yes.
All right. So you have an officer in the video that you can see getting out of a car, and he's confronting this one person. There's not a group of people with him. This is just this guy, Eppinger, by himself, walking, right?
That's what the footage showed, yes.
And would you agree with me, the footage shows the officer telling him to get on the ground, trying to apprehend him, right?
That's what it showed, yes.
Now, the video, that body camera from that first one, it doesn't show, there's a point where it kind of goes on the ground and you can't really see much more, but you can still hear what's going on, right?
Correct.
And you hear the shots.
Correct.
Okay, now, so this guy, Eppinger, that we see first in the first video, we see him again in the dash cam, the second video that was shown. Is that right?
Yes, sir.
Okay. And would you agree with me that the dash cam from that second video is not from Officer Rogers' car, it's from the other car? Is that true?
No, that's from Officer Rogers' car that he exited out of.
That's Officer Rogers' car?
Yes.
Okay. So you see the dash cam pointing out, and there's a point where you see both Officer Rogers and this guy, Eppinger.
He keeps calling him this
both in
guy.
the frame of the video. You agree?
I think you're kind of mistaken. What you see initially, the position of the body cam of him exiting the car, the door opening. Once he closes, you see the body camera as he has interaction with the gentleman.
Okay.
The second video that was shown was the actual car, that's the camera that's mounted inside of the vehicle, the dash cam itself.
Right, and that's what I was talking about, the second video. And you agree in the second video, at some point, they come into the frame of the video and you see both individuals, right? Correct. You agree with me that the officer doing his job is trying to interact with Eppinger, this guy Eppinger, right?
Yes, sir.
And then you hear a series of shots. And at the time that you hear the shots, you actually see Eppinger shooting at the officer. Would you agree with that?
Yes, sir.
All right. You'd agree with me that there doesn't appear to be anyone else around.
Not that I saw, no.
Right. There's no one advising or encouraging this guy, kid, whatever he is, Eppinger, to do what he's doing. He appears to be acting on his own. Is that right?
That's what it appears, yes.
And then you hear a second set of shots. And am I correct that that is after this guy Eppinger runs off, you hear some other shots, which will be another officer shooting at him, right?
No one was shooting. I don't know who was shooting, but you do hear more gunfire.
Okay. And at that time, when Eppinger runs off and runs around the corner, there's no one else with him.
With Eppinger, you mean?
That's
No,
right.
I didn't see anyone. No.
Okay. There's no one who appears to be running with him or anything like that, right?
Not from the footage, no.
Okay. You don't know this kid Eppinger, do you? And I say kid, out of this guy Eppinger.
No, I don't know the young man. No, sir.
Okay. All right.
And of course, Keith
Would you
Adams
agree with
representing
me?
Young
And
Thug in this case.
This is what I heard, and I want you to tell me if I'm
We know where he's going with this.
if I'm correct, if this is what you heard as well. In the very first video, when Officer Rogers gets out of the car and he's telling Eppinger to get out on the ground, did you hear Eppinger saying, "I didn't do nothing, I didn't do nothing"?
Yes, I heard something to
All right.
remember what you said. Yeah, correct.
And again, Rogers pulls up in a marked police car, as far as you know, right?
Correct.
Okay. And so, you know, this verbiage, "I didn't do nothing, I didn't do nothing," it appears that he is, I mean, you don't say "I don't do nothing" to someone who's not a cop.
Objection, speculation.
I withdraw it. I withdraw it. All right. I don't need you to play it again, but if I'm correct, looks like he had on some white pants and a silver bubble jacket kind of thing.
That's what it appears. Looking at the
Okay.
video.
All right. Sergeant Davis, I think that's all I have.
All right, any other defense attorneys with questions for this witness? Any redirect?
No redirect, Your Honor.
All right, thank you for your time. You're excused. Call your next witness.
All right, so here we go. So now let's get into, so leading up to all of this, Christian Eppinger and his representation, they were wanting to seek immunity, which is interesting in this case because they're essentially saying, yeah, he did these things, but he's doing it in self-defense, right? So it's an interesting way. It's an interesting route they're taking because I don't know how this is going to play out in court. We're going to get to see it live here in the next few weeks. But then you have the state's response to, and let's just go ahead and read this. The state's response in opposition to the defendant's motion for immunity from the prosecution. And let's get into it and see what the state has to say about them wanting to get immunity, which, man, shooting a cop. Oh, gosh. I don't know how you make it out of that one. We'll just have to wait and see. Comes now, the state of Georgia and respectfully submits the response opposing defendant Christian Eppinger's motion for immunity from prosecution, which defendant filed on April 2nd, 2024, and states as follows. Defiantly embodying the exact sort of extreme public violence that is trademark of the criminal street gangs, including YSL. All right, well, YSL's not a gang. Let's get over it. Defendant Eppinger, a YSL gang member, brazenly opened fired on Atlanta Police Department officers in the lawful discharge of their duties. He continued attempts to escape the consequences of his violent and reprehensible gang crimes are both baseless and indefensible under any reasonable or legal standard. Eppinger's obvious motivation in his attempted murder of Officer David Rogers was to evade a lawful arrest and avoid responsibility for his involvement in a recent gang-related armed robbery targeting innocent members of our community, all while furthering the interest of YSL. I mean, okay, let's get off of YSL. In pursuing his groundless motion, he seeks a superior court endorse I don't know what that word means. I'm sorry, y'all. To intensify his gang's malicious campaign of terror through improperly eluding the charges against him and calculated efforts to garner publicity. That's going to bother me. Hold on a second. The protection, backing, or support of a particular person or organization. Aegis. I've never seen that before. All right, here we go. The court should grant no such indulgence of Eppinger, even had Eppinger particularized his baseless motion. Georgia law forecloses immunity where, as here, lawful arrests are legally response in opposition. State versus Eppinger, page 1. Okay, resisted. Eppinger's motion is entirely lacking in both legal and factual substance. Therefore, this court should unequivocally deny Eppinger's motion. The statement of facts. Here we go. YSL's existence as a criminal street gang, the persistent and pernicious connection between violence and YSL, as well as YSL's broader affiliation with the Bloods, is widely recognized and can be readily verified by reliable, unquestionable sources. Really? I don't think so there either. Each of these factors independently meets the criteria for judicial notice under OCGA 242201. Consequently, the court is well within the authority to take judicial notice of the violence nature of gangs in general, that of YSL in specific, and the fact that the defendant's actions captured on video, unchallenged and irrefutable, are entirely consistent with both. They're not disputing that he shot those two police officers, or shot the one and shot at the other police officer, which is, man, it's tough looking at how much time that he's facing. They're just saying, all right, hey, we can't say anything about this, but he did it in self-defense. Just give him immunity. I don't know why they would do that. We'll keep reading. The armed robbery. Here's what happened there. On October 12th of 2021, the Atlanta Police Department responded to a report of an armed robbery at Cleveland Avenue. Darius Smith was standing near the playground in a park, conversing with friends, when Eppinger and fellow YSL co-conspirator approached him and demanded, "Give up that chain." The victim further stated that one YSL gang suspect pointed his firearm at his head, while the other pointed his weapon at his ribs and proceeded to steal his diamond earrings, diamonds, and gold necklace, 2 iPhones, and his car keys. YSL gang suspects then entered the victim's white 2003 GMC Savannah, they've got the tag number there, and fled the scene at a high rate of speed, turning westbound onto Cleveland Avenue. An investigation by the Atlanta Police Department led to the identification of Christian Eppinger and Durante Beebe as the two armed robbers. Eppinger being identified by Smith via photo lineup. Both Eppinger and Beebe were documented YSL gang members at the time. The crimes occurred in what is known as YSL gang territory. Cleveland Avenue, we know, or Cleveland Avenue, as y'all say. The hot spot for some of the crazy stuff that goes on. Attempted murder of Officer Rogers. We already saw this, but we'll read through it anyway. On February 7th of 2022, Eppinger was wanted for an armed robbery that he committed with Mr. Beebe on October 12th. Atlanta Police Department's fugitive unit observed Eppinger at 111 Claire Drive, Southeast Atlanta, 30315, at which time they began to close surveillance and observe him getting into a Jeep driven by a female driver. The Jeep was stopped at 387 Cleveland Avenue and then proceeded to 221 Cleveland Avenue, both locations within known YSL stronghold territory. Eppinger then exited the Jeep and walked toward 2637 Old Hapeville Road in the Colonial Square Apartments. We heard this brought up during the YSL trial too. Shortly thereafter, Officer Rogers, the first marked vehicle on the scene, arrived in full uniform, exited the vehicle, and gave Eppinger loud verbal commands to get on the ground. But Eppinger, true to YSL expectations, did not comply. Continuing his gang-motivated defiance. What? Come on, man. Eppinger pushed Officer Rogers and gained space between the two, at which time Officer Rogers attempted to draw his taser. Before Officer Rogers could discharge the taser, Eppinger produced his own firearm and began shooting at Officer Rogers multiple times, striking Officer Rogers 6 times to include his right shoulder, above his knee, and 1 hit to the back of the head. Oh my gosh. Eppinger then attempted to fire at Detective William Johnson, who had arrived as backup, as he fled northbound on foot through the apartment complex. This ain't looking great. After Eppinger fled, law enforcement issued a be on the lookout alert for him. Members of the fugitive unit located Eppinger running behind building 34, headed directly toward apartment 35D with a gun in his hand. Eppinger then forcefully kicked in the apartment door and entered without authorization. After a standoff with police, Eppinger was arrested and transported to Atlanta Public Safety Headquarters. During his interview, Eppinger was Mirandized and admitted to shooting the officer. After his interview, and once he was transported to Fulton County Jail, Eppinger made a recorded telephone call where he, again, consistent with established gang and YSL behaviors, Eppinger bragged about the shooting. Coveting attention for his crime and gang, Eppinger implored the caller to check his YouTube or drop his music because his profile is going up on YouTube. Gosh. Eppinger then continues throughout the call laughing about the shooting. At the time of the attempted murder of Officer Robert Rogers, Eppinger was on probation for a prior robbery. Eppinger has made no claim and has presented no evidence of excessive force on the part of law enforcement. And as we learned yesterday, y'all, the state isn't calling any witnesses. It's not a great sign. Not a great sign here. Argument and citation of authority. We don't really need to get into that in the conclusion. Oh, man. This is tough. Eppinger's armed, hyper-violent attack on the officers in this case present yet another chapter in the tragic and destructive history. Eppinger has provided this court with no legal authority or substantive his indefeasible assertions. We'll let it go, y'all. I'm struggling today. Additionally, Eppinger has failed to present even the slightest indication of facts that would satisfy his burdens under the established and controlling statutory and case law governing his claims. Accordingly, the Honorable Court should deny defendant Eppinger's motion for immunity from prosecution and respectfully submit this the 16th day of December 2024. What do y'all think? Is he going to get this one? Fannie Willis and Adam Abadi look like they're teaming up for the rest of this trial. It's not looking great. We got a lot of evidence we've seen already. We've got the body cam, we've got the dash cam, we've got the footage from someone's Ring camera, which shows Christian clearly doing the things that he admitted to, and it looks like his defense isn't denying, which is odd to me. So I don't know how they're going to play this out. I would be highly shocked if they got immunity, but y'all have to let me know what you think in the comments and in the chat. Mr. Brown says they are going to use everything against him. You can't beat everything. All they can say is it wasn't for YSL. D-Lo says, oh yeah, he over with. God dang, D-Lo. Do we have the call? Yes. Yeah, they have the call. What immunity is he looking for? Let me see. I tried to find the original document and I was having trouble finding it, but they said they want to get immunity from prosecution on this. And he's claiming self-defense. And let me see what else they're saying. And because he's claiming self-defense, then he should be able to have immunity. I don't see it happening. Right Street said he's good. Yeesh. So we're gonna see the rest of this. I'll be interested to know how y'all feel about that. I had one more thing I want to get to, but we might save that for tomorrow. I'm gonna let y'all get out of here and get some lunch. Thank you everybody who supported. Make sure y'all like the video on your way out. We almost had 1,000 of y'all like the video. Thank you so much. We're gonna be back and dropping a couple of videos this afternoon and tomorrow morning as well. So y'all make sure you subscribe, hit the notification bell so you don't miss any time that we go live. I hope y'all have a great rest of your day. And as always, you know what you got to do. Keep growing, keep pushing, keep it classy. We go. Peace. Yeah.